Hey everyone, welcome back. It's time for some more trending legal tidbits. Today we're going to be looking at a case that went before the Supreme Court.
Yeah, this one's a real doozy.
It is, and it involves Facebook.
Facebook, always in the news.
Always,
Huh?
yeah, they just can't seem to stay out of it, can they?
Nope, not these days.
So this case is Facebook v. Amalgamated Bank. And basically it all comes down to Facebook's 2016 annual report.
Okay.
They talked about data misuse risks. But the thing is, the Cambridge Analytica scandal,
Yeah.
that massive data misuse event,
Yeah.
that had already happened, like way back in 2015.
Oh, wow. So they're talking about these risks, but they've already had this huge issue.
Exactly. And that's what the plaintiffs' Amalgamated Bank are saying.
Hmm.
They're saying, hold on a second. Facebook basically implied this kind of major data breach hadn't happened when it already had.
That's pretty misleading.
Right. It's this whole legal question of whether Facebook's statements were what they call misleading by omission.
So not lying outright,
No.
but leaving some pretty crucial information out.
Exactly. And that's what makes this case so fascinating. So to really get into the weeds of it, we're going to be looking at the oral arguments that were presented to the Supreme Court.
Ah, okay. So we can hear both sides of this legal showdown.
Yeah. And trust me, it gets pretty interesting. The justices were throwing out all sorts of hypotheticals.
Oh, really?
Yeah. Trying to figure out, like, when a company absolutely has to disclose a past event,
Hmm.
when they're talking about future risks.
Hmm.
I mean, we're talking fires, meteor strikes, even slipping on a wet floor.
Wow, they really went there.
They did. It was wild.
Mm.
And it all comes back to how they think about what a reasonable investor would want to know.
Yeah. So would a reasonable investor expect a company to say, hey, by the way, we had a fire last year, even if they're just talking about fire risk in general?
Right. And you can see how some of the justices seem to want stricter rules, where companies basically have to spell everything out.
Okay.
While others think, companies should have a little more leeway
Hmm.
in how they describe potential risks.
Yeah, I can see both sides. Like, you want investors to have all the information, but you also don't want companies drowning in paperwork every time something minor happens.
Totally. And speaking of information, this whole idea of materiality kept popping up.
Materiality, what's that all about?
Well, it basically means, would this piece of information actually make a difference to an investor's decision?
Ah, so like would knowing about one small fire actually change whether or not someone invests in a company?
Exactly. And both sides in this case seem to agree that companies don't have to disclose every single thing that's ever happened.
Okay.
Only stuff that a reasonable investor would care about.
So that's where it gets tricky, right? Like, what exactly would a reasonable investor care about?
Right. And would a reasonable investor care about a major data misuse scandal?
That's a good question.
I mean, Facebook's lawyers argue that investors wouldn't expect them to disclose every single data incident.
Hmm.
But then Justice Sotomayor brought up a good point.
Oh, yeah.
She said, if Facebook knew that millions of users' data had been misused,
Right.
wouldn't that be something an investor would want to know before buying their stock?
Yeah, I mean, that seems pretty material to me.
It does. But here's where it gets even more complicated.
Uh-oh.
While materiality is important, this case actually hinges on whether Facebook's risk disclosures were false or misleading.
Okay. So even if the missing information was really important, if the statement itself wasn't technically false,
Yeah,
Facebook might be off the hook.
exactly. So let's dive into the nitty-gritty of what Facebook actually said in their report.
Okay.
They warned about data misuse, harming their reputation in business,
Right.
but they phrased it as something that could happen in the future.
I see where this is going.
So now the debate is whether the Cambridge Analytica event was technically hacking.
Why hacking?
Well, because Facebook claimed their warnings were just about hacking incidents.
Oh, so they're saying we warned you about hackers, but this wasn't hacking.
Yeah, something like that.
Yeah.
But the Ninth Circuit Court wasn't buying it. They basically said, nope. Facebook's disclosures covered any unauthorized data access or misuse.
Not just hacking.
Not just hacking.
Yeah.
So if we follow the Ninth Circuit's logic, Facebook was saying, hey, this could happen, when they knew it already had happened.
Ooh, that's not good.
It's a real legal plot twist.
Yeah.
And it could have massive implications for other companies.
How so?
Well, if the Supreme Court agrees with the Ninth Circuit, it could force companies to be a lot more careful about how they word their risk disclosures.
Makes sense. They don't want to get caught in the same trap.
Exactly.
Yeah.
And even the justices were expressing concerns about this. They were worried that forcing companies to reveal every single past event
Yeah.
could lead to what Justice Kavanaugh called information overload.
Oh, I can see that. Like, investors would be drowning in information.
Right. He even suggested that maybe the SEC, the agency that regulates all this stuff, should step in
Mm.
and create clearer rules for risk disclosures.
So companies know exactly what they need to disclose and
Yeah,
what they don't.
exactly. It's
Oh,
like,
well,
where do you draw the line? Justice Alito used the example of a fire.
a fire.
Yeah. He said if a company discloses the risk of fire damage, do they have to report every burnt pot of coffee?
Uh-huh. Good point. I
Uh,
mean, that seems a bit excessive.
right. It all comes back to that reasonable investor idea.
Yeah.
What would an average investor actually consider important?
It's all about context.
Exactly. And this case is happening in 2016. So, whatever the Supreme Court decides,
Yeah,
it's going to influence how companies write these risk disclosures going forward.
for sure. This isn't just about Facebook
Right. This is about how all publicly traded companies talk to their investors.
and how much they reveal about what's happened in the past.
Exactly.
Makes you think.
It does.
It really does. And this whole thing raises some questions about the SEC's role, too.
Yeah. How so?
Well, they've always been kind of hesitant to impose, like, super strict disclosure rules.
Yeah.
They don't want to overwhelm companies with paperwork.
Right. Makes sense.
But this case could really push them to rethink things, especially when it comes to these risk factor disclosures.
That's a good point. This could be a real wake-up call for the SEC.
Exactly. But, let's go back to Facebook's argument for a second. The whole Cambridge Analytica wasn't hacking thing.
Oh, yeah. What do you make of that?
Well, the Ninth Circuit actually shot that down. They said Facebook's disclosures were broad enough to cover what happened with Cambridge Analytica. It wasn't just about hackers breaking in. They were talking about any unauthorized access or misuse of data. So, according to them,
Yeah.
Facebook was basically saying, hey, this could happen, but don't worry, it hasn't happened, when it already had.
Wow. If the Supreme Court sides with the Ninth Circuit on that, that could have huge consequences for other companies.
Oh, absolutely. Companies might have to start getting a lot more specific about past events when they're talking about potential risks.
And that's where it gets really interesting for investors, right?
For sure.
On the one hand, more transparency is always good. We want to know what risks we're taking as investors. But on the other hand,
Yeah.
if companies start disclosing every little thing, it could be total information overload.
Right. How are we even supposed to make sense of all that? It's a tough balance.
It is. This case really highlights that tension between, protecting investors
Yeah.
and also giving companies some flexibility in how they communicate.
Exactly. And it makes you think about the ethical side of it, too.
Yeah, for sure. Like
Yeah.
legally, companies might only have to disclose certain things.
Right.
But ethically, shouldn't they be more transparent? Especially when it comes to something as sensitive as data misuse.
That's a really good question. It gets to the heart of corporate responsibility, Should companies just always err on the side of full disclosure, even if it means their stock price might take a hit? Or do they have some kind of duty to their shareholders
Right.
to present things in the most favorable light possible, even if it means leaving some stuff out?
Tough call. And it also makes me think, as an investor, how much responsibility do I have to do my own digging?
Oh, yeah.
Even with these super detailed disclosures, there's always a chance something unexpected could happen.
Absolutely. Investors need to remember that every investment has some level of risk,
For sure.
and no disclosure can completely eliminate that risk.
So for our listener who's trying to stay on top of these trending legal tidbits, what are the key takeaways from this case so far?
Well, first, it shows that this whole debate over how much information companies have to disclose, that's not going away anytime soon.
Okay.
And this case could really have a big impact on that.
Mm.
Second, it shows that what happened in the past,
Yeah.
that can be just as important as future predictions when you're trying to understand a company's risk.
Makes sense.
What happened before can often shed light on what might happen down the road.
Right.
And third, this case could have ripple effects on the SEC,
Yeah.
and how they approach disclosure regulations. They might start pushing for clearer guidelines
Okay.
on what companies have to reveal about past events.
So this isn't just a legal battle. It's a potential turning point in how companies and investors communicate.
Exactly. But before we wrap things up, I want to leave our listener with something to ponder.
Oh, okay. I like it. Hit me.
Okay. So beyond all the legal stuff, what should companies be thinking about ethically when they're deciding how transparent to be? Especially when it comes to risks they've already experienced, like Facebook and Cambridge Analytica.
Right. It's a question that goes way beyond the courtroom, doesn't it? You get to the heart of corporate responsibility.
Exactly. Like, should companies always choose to be completely open, even if it means their stock price might take a hit? Or is there some kind of obligation to their shareholders to present things in the best possible light?
Even if that means leaving some things out.
It's a tough one. It really makes you think.
It does. And, it also makes you think about us as investors,
Yeah. What about our responsibility?
right? Like, how much effort should we be putting in to really understand the risks involved?
Yeah.
Even with all these disclosures, companies can't predict everything,
Oh,
right?
exactly. There's always a chance something unexpected could happen, no matter how much information they give us.
Exactly. So it's important for investors to remember that every investment carries some level of risk, and no disclosure is going to completely eliminate that. That's a good point. I guess it's about being informed, doing your own research, and accepting that there are always going to be unknowns.
For sure. We can't just sit back and rely on what companies tell us. We need to be engaged, asking tough questions, and doing a little digging of our own.
Absolutely. Well said. So to wrap up these trending legal tidbits, it seems like this case really highlights that tension between protecting investors
Mm.
and giving companies some leeway in how they communicate.
Yeah, for sure. And it reminds us that what happened in the past can be just as important as what a company says about the future.
And beyond all the legal stuff, it really makes you think about corporate ethics, investor responsibility, and this whole ever-changing world of data privacy.
It's a lot to unpack.
It is. Well, a huge thank you to our expert for breaking down this complex and super relevant case. And to our listeners, thanks for joining us for this deep dive into Facebook v. Amalgamated Bank. We'll be back next time with more trending legal tidbits. Until then, stay informed and stay curious.